Hello everyone, this is Crypto Bitlaw. Just wanted to do a quick video for you today. This is going to be an update or continuation of a recent video that we posted regarding the analysis of the HEX class action lawsuit. And this video is going to focus on an interesting development in the case wherein the court in that particular case denied the plaintiff's motion to force an alternative service on CZ, Changpeng Zhao, the CEO of Binance. Now, ultimately, what the plaintiff in that case wanted to do was serve CZ through Twitter because they were unable to locate him through traditional means in order to serve him with a copy of the lawsuit. And so they argued to the court because he is pretty much hopping around from jurisdiction to jurisdiction and seeking to circumvent the jurisdiction of the court, the plaintiff wanted to serve him with a copy of the lawsuit via Twitter in order to initiate and continue the proceedings and rope him, CZ that is, into the lawsuit. As always, if you like this content, please hit the like button, subscribe to our channel, and follow us on Twitter. We are at Crypto Bitlaw. We'd really appreciate your support going forward. And with that said, let's jump right in. We can see here on the 14th, there was an order denying the plaintiff's motion for alternative service. So we could take a look at the motion right here, or actually the order rather, and let's see what it says. So here we could see that the plaintiff filed a motion for alternative service, and the court reviewed it and ultimately denied it. But there's some interesting points in the court notes here. It says that the plaintiff notes that Binance has been described as an international cryptocurrency exchange that hops around from jurisdiction to jurisdiction to avoid regulators. It states that the plaintiff has successfully served process on the corporate entities in this lawsuit, but has failed to serve each of the individual defendants, who the plaintiff notes are Chinese nationals, whose country of domicile cannot be ascertained. Continues and states that the plaintiff has taken extensive action to locate the whereabouts of individual defendants who are officers of Binance, and all of the plaintiff's efforts have been fruitless. It also says that the plaintiff describes these individual defendants as international ghosts. This order also reveals that the plaintiff hired a private investigator, but they could not even identify the country of residency for a single Binance officer. The private investigator was, however, able to identify the Twitter accounts associated with the defendants Zhao, Ted Lin, and Yihei. Continues, on November 12, 2021, undersigned counsel tweeted a copy of the summons and a link to the complaint in this case to all three Twitter accounts. Twitter has verified each individual account, and plaintiff notes that each user utilizes their account on a regular basis. So this is a new one for me. They're trying to serve these people via Twitter. I guess that didn't really stand too well with the court. Let's continue. The court then provides legal standards for serving individuals. They assert that courts are given discretion to determine when particularities of a given case require alternative service. More legal standards, and then they enter the discussion, which is pretty much a reason for why they issued their order. So here's the court saying in black and white, as plaintiff has exhausted all other methods of service, he asks to serve Changpeng Zhao, Yihei, and Ted Lin via Twitter. Wow. Okay. In support of this request, plaintiff cites to district court cases where the court authorized plaintiffs to serve via social media under Rule 4F3. And then they cite to a case, Who's Here Incorporated versus Oren, authorizing service on an individual in Turkey by email and through Facebook and LinkedIn. And then another case where individuals in India were served by email and Facebook. The court also cites a case where that particular court authorized service of an individual in Kuwait via Twitter because service via Twitter was reasonably calculated to give notice and was not prohibited by international agreement. Okay, they state that the reason that the court did it in that case is that Kuwait was not a signatory to the Hague Convention. Here, In this case, the plaintiff is unable to locate the country in which the individual defendants reside. The plaintiff merely speculates that defendant Zhao may reside in either Taiwan or Singapore. Singapore is a signatory to the Hague Convention, but Taiwan is not. Without further proof of the country of residency for the individual defendants, the court cannot accommodate plaintiff's request to serve via Twitter. The court can only speculate as to whether service by Twitter is prohibited by international agreement, as the country of residency cannot be identified. Moreover, in each case where a court approved service via social media, the district court knew the country of residency of the person to be served, where uncertain, was presented with only one potential country of residency. Unlike those cases, here the defendants are alleged to be Chinese nationals with potential residences in a number of countries, including Taiwan, Singapore, Malta, or the United States, to name a few. Plaintiff has not presented the court with enough information to determine the country in which defendants reside, or by extension, determine if service via Twitter would violate international law. Accordingly, the court must deny the plaintiff's request. Okay, so unpacking that, it seems like, as explained by the court is unwilling to go so far as to serve these defendants via Twitter in what it appears to me is an effort to avoid some sort of international, I guess, kerfuffle. I guess, the situation with China and Taiwan and all of that seems kind of tense right now. And to do this and to try to assert jurisdiction over these defendants who may or may not be residing in one of those countries would just escalate those tensions. So based on that and the applicable jurisprudence as stated above, the court denied this plaintiff's request.
So all in all, you can strike this up as a win for CZ. If you look at the actual function of service and what it is, when a complaint is originally filed initiating a lawsuit, naturally you have to, as a plaintiff, deliver a copy of the claim to each defendant. And that in itself is service. And a lawsuit, it's not complete without service. The reasons to serve the defendant are painfully obvious. Defendants in a given case need to know about the claims against them in order to be notified of the date and the time and the place that they can show up in order to defend themselves. So if they don't have notice of those claims and a set time and place to defend themselves, how are they going to defend themselves? So it's an integral part to why the court denied service via Twitter in this particular occasion. As we stated earlier, courts have permitted service via alternative means in the past. I know sometimes in state courts, if you can't serve a defendant directly, sometimes the court will permit you to serve them via an ad in the paper or something to that effect. In this day of digital social media and whatnot, I guess this is a more effective manner of doing so. But it seems that in this case, the court is hesitant to extend alternative means to the plaintiff, due in large part to the ambiguity in terms of where CZ actually resides, whether or not it's in China or I think it's Singapore was the other one that was mentioned. The fact that they also reasoned that one of the countries was a signatory to this Hague Convention and the other was not. So when you have a country that signs on to a convention that establishes alternative means for service and jurisdiction, asserting jurisdiction over international defendants, you'd obviously want to comply with international law. Furthermore, as we noted earlier, given the rising tensions between the United States and China in regards to Taiwan and all sorts of other international issues, the court is hesitant to escalate those tensions by asserting any sort of dominance of U.S. jurisdiction over international defendants, especially when it's unclear as to whether or not those defendants should or should not be subject to the jurisdiction of the United States. So all in all, I thought that was an interesting update. I hope you guys enjoyed the content. We're going to try to keep you guys updated as this case develops. Again, if you like the content, please hit the subscribe button, hit the like button, and follow us on Twitter. We are at CryptoBitLaw. Thanks for watching, and we'll see you guys in the next video.